So you think you need a trust, but do you really? Well, let's talk about that in the next Wealth and Whiskey video. Welcome to Wealth and Whiskey. I'm Roger Kiger. I've been a financial planner for about 30 years, helping people build wealth and protect their legacies. So Wealth and Whiskey is about full transparency, whether some folks want to hear it or not, but that's why we call it aged and unfiltered. But today we need to talk about trusts, because a lot of times I hear people say, I just want to put my stuff in a trust. Well, maybe it's not clear what a trust is or what a trust does. So let's talk through that at a really high level. But I need to give you a disclaimer, because I am not an attorney, I am not providing legal advice, and I really just want to explain this conceptually, so that if you think you need a trust, please consult with an attorney, because they'll have to draft the paperwork for this. But I've been around this for a long, long time and seen a lot of different types of trust. We're only going to scratch the surface in trying to identify whether or not it's really what you need, and maybe a few clarifying points to help you make that decision. So when somebody says, I need a trust, the first question is, well, why do you think you need that? And most of the time, it's because someone says, well, I want to protect the assets for my spouse or for my kids. I get that. Well, then my next question is, protect the assets from whom, right? So maybe it's a remarriage in a spouse. Maybe it's kids that might get divorced and you don't want to lose those assets. So there's a lot more to it than just taking a will and saying, I want to put everything in a trust. So let's break down the types of trusts first, because that's really important in talking through long-term scenarios where you utilize trusts. The most common types are revocable versus irrevocable, and they are exactly what that sounds like. Revocable means you can cancel at any time. Most people do a revocable trust while they're alive. What this does is allows the assets that they put in that trust to bypass probate, keeps everything private. If there's a concern about kids or somebody contesting the estate to try to get some assets, this is really helpful. It's a great tool for that. Provides a lot of privacy when somebody passes away, because it's in a revocable trust while you're alive. You can add assets, take them out, do whatever you want, but the minute somebody passes, it becomes irrevocable. Now, one mistake I've seen is people say, yes, I want a revocable trust. They pay a bunch of money to an attorney, they set up a trust, and they assume it's done. Doesn't work that way. You have to retitle the assets into the name of the trust. You have to retitle the deeds to the property, the titles to the cars. Anything that you want to go into that revocable living trust has to be retitled, which includes bank accounts, investment accounts, anything that you're trying to keep into that trust process. More often than not, I see people get a trust kit. They bought a trust online, and they think they're done. They've never moved any of the assets into the trust, and it makes no difference whatsoever. There's just zero benefit to doing it that way. So if you want a revocable living trust, please implement the next steps, otherwise it doesn't help you. So that does help, though, bypass probate and keep everything private. But then at that point it becomes irrevocable, and it follows the wishes of the grantor, of whoever's put those assets into that trust. And there is some protection. If you give assets to kids and you're worried about a divorce and a spouse having access to some of those things, there is a lot of asset protection for kids that way. There's some asset protection for surviving spouses. So there's a lot of benefit to a irrevocable trust at that point. The other challenge with that, though, is you have to have a trustee. So what does that mean? Well, if you think about setting up a essentially its own business that manages these assets and takes care of them for the trustee's for the trust beneficiary. There's a trustee that has to manage that the whole time an irrevocable trust is in its process, right? So who's going to do that? So banks do it, trust companies do it, wirehouses and brokerage firms do it, but they charge a fee. And most of them charge a minimum fee, which means if you're looking at putting $50,000 or $100,000 or less into a trust for kids or spouses or beneficiaries, the minimum fee sometimes can be $5,000 or $10,000 per year because there's liability associated with being a trustee. There's work associated with being a trustee. Somebody has to sit down and meet with those beneficiaries, kids or spouses or whoever, and distribute those assets in accordance to the guidelines that were set up in the trust. So as a trustee, there's a fair amount of work there, which is why most trustees charge for that. If you don't use a corporate trustee, maybe you use a sibling or a friend or a child as a trustee. You can do that, but I will tell you it's a pretty big ask to say, hey, I need you to manage this trust forever until the beneficiaries pass or whatever causes that trust to terminate. Maybe it's a certain age for the beneficiaries. But there is a rule that says trusts cannot live forever, but most trusts, if they're irrevocable, are around for a long time. So you're asking a trustee as a personal favor, if they're not a corporate trustee, you're asking them to manage that for a long, long time. So it can sometimes be really difficult to find the right personal trustee to manage that trust after you pass away. So I think that's one of the biggest issues is understanding and finding the best person to be that trustee. So that's revocable trusts and irrevocable trusts at a really high level. But let's talk about some ways that maybe you don't need a trust. So there's another misperception that says, hey, I've got a will, everything's going to go through my will or my trust, and I'm good. Everything's set up. Remember us talking about retitling assets into the name of the trust? Well, the same is true if you have any assets that have a beneficiary or a joint owner. Those assets don't go through probate and they won't be put into a trust unless you retitle them that way. So what does that mean? Most retirement accounts, most annuities, you can even add beneficiaries to bank and investment accounts. So if I add a beneficiary to any of those assets, and I have 43 trusts, and I've got the best will in the world, and I've got all this estate plan set up, and I feel comfortable with it, but I still have a beneficiary on that asset that is not the trust, that asset goes directly to that beneficiary regardless of what any estate plan says. That's essentially a contract that says that asset goes to the beneficiary first before it goes into the estate or a trust. So to do that, a lot of times you have to name the estate or the trust as the beneficiary, right? So the other mistake that I see a lot is something that's owned jointly. So in Tennessee, for example, it's called joint with rights of survivorship. That means the surviving person that owned it jointly gets that asset. And I've seen this done a lot with homes, for example, when parents just want to give an asset to a child or to children, they just add that person to the deed. So what happens is that home doesn't go through probate, it goes directly to that beneficiary. So it's a pretty easy way to make sure you transfer that property. However, check with your tax people because technically that is a taxable gift depending on the amount or the value of that asset. So if it's a $200,000 home and you've added the name of one of your children to that deed, now there's two owners, you technically made a $100,000 gift that could be taxable. So make sure you're looking into those kinds of things. But the whole point is, with a beneficiary or with joint ownership, sometimes you can get assets to those beneficiaries and not have them go through probate, which might negate the whole need for a trust, right? So there's some things that you can do that make estate planning a lot simpler and a lot easier without spending a whole lot of money setting up a trust that isn't either implemented or maybe you just didn't really need to start with. But every situation is always different. And the answer is, do you need a trust? The answer is always, well, it depends, right? So there's a lot of questions, a lot of details, and this is why it's really best to engage an attorney to walk through those steps. So I hope this is helpful at a really high level to answer the question about, do I need a trust? It depends. So hopefully if you've got any questions, please share those with us. We're glad to help, and we'd love to help you start your financial journey by downloading the link below to our Legacy Blueprint. So please like and subscribe to our channel because we want to make sure you don't miss any of the issues, and share your comments with us if there's something you'd like to see us talk about. Be glad to do that, and we really appreciate your time. So I'm Roger Kiger. Thanks so much, and we'll see you again next time. Cheers.